Okay, good morning everyone. So, what is today's article about presidential reference? This is a very specific issue. You can get current affairs, lot of current affairs on this even in further days. Okay, right. So, in today's discussion, we'll be dealing with a specific issue. You will be dealing with the concepts of separation of powers. There are some concepts that you need to know. Separation of powers, federalism, and how various parts, like you have, when you talk about the concept of state, one of the concept is government, and separation of powers is about legislative, executive, and judiciary. In India we do not have strict separation. Okay, it is not a watertight separation of different wings of the government. Why do we have separation of powers in the first place as a concept? Can anyone tell me? Exactly. To not place arbitrary power in one hand. Clear? What will happen if we place? It can lead to abuse of power. We have discussed this multiple times. So, entire constitution is about checks and balances. Clear? It is in this context we have the institution of governor. So, is this article about president or is it about governor? There is a context to this. On 8th April, we have had a judgment this year, 2025. There was a judgment where the Supreme Court imposed certain timelines on governors, time, that the time that a governor can take for taking a decision on a bill. They cannot just sit on those bills without taking any action. A strict timeline was enforced. Okay. So, this article is in the context of that issue. So, today we will be dealing with the present article, the advisory jurisdiction of Supreme Court, when will President ask Supreme Court for an advice, and the context. What is the context that we are talking about? The governors, timeline. Okay, that entire issue. We will be covering both these issues under the umbrella of checks and balances, separation of powers, how it will have an impact on federalism. Clear? Okay. So, present article, let's know the fact. Recently, the President of India, as per the provisions of Article 143, asked certain doubts or asked for an advice to the Supreme Court. Supreme Court has to have a 5 bench, minimum of 5 bench, 5 judges bench. I mean, you need to have at least 5 judges as per this Article 143. Okay, so these 5 judges should come together, discuss this issue, and give an advice to the President. Is it mandatory? Is it mandatory for the Supreme Court to give that advice? No. And there should be a logic as to why they will not give an advice. Usually that logic is it is not relevant constitutionally. Clear? And is it mandatory for the president to accept that advice? No. But again, even on the part of the president, there should be a very strong logic as to put it aside. Why is this kind of respect given? Otherwise, the institution respect will come down. Okay? It is not binding, but having said that, you should respect the institution. Clear till now? Everybody, when they're doing their job properly, you will not find a reason to reject the recommendation. As simple as that. All clear till now? What is Article 143? Great. Okay. Now, let's see. What is the purpose? You can note these points down. This constitutional tool maintains balance between separation of powers and pragmatic governance needs. How do you present it in your short notes? You don't have to write down entire sentences. Write these keywords only. Separation of powers, pragmatic governance needs. So you can say Article 143 is equal to separation of powers plus pragmatic governance. So this can be the intro of your answer. Clear? Shall I move forward? Okay. Now, where is this there in the Constitution? Okay. Part 4, Indian Judiciary. What is the presidential power? To seek an advice. What is the scope of reference? This is very important for prelims. On what matters can the President of India ask Supreme Court for an advice? Matters of public importance and pre-constitutional treaties. What do you mean by pre-constitutional treaties? Right. Correct. So, why is this a part of the jurisdiction or the scope of reference? Because if they have an implication on present day governance, the government should have a certain sense of clarity. It is for that purpose. Clear? Now, before we dwell into the further details and the procedures, you should understand the philosophy behind why democracies need this advisory jurisdiction. See, I'll give you a small visual. This, let's say we are talking about separation of powers. If the legislatures and executive and judiciary are working in watertight compartments, you need certain bridge. Correct? If that bridge is not there, they will function in their own way, and the very purpose for which they are existing might get defeated. Correct? Each of them should show accountability to one another. Correct? So this Article 143 is like that bridge. It bridges the separation of powers with practical governance needs. Clear? That is the first aspect. Second one, there are grey zones. For example, in 1993, when the President of India asked a question on whether there was a temple existing on Babri Masjid side, Supreme Court refused to answer. Why? Because it is legally not relevant, according to the Supreme Court. So, when Supreme Court denied that this is not a legal matter, the methodology or the approach to resolve that conflict will take a different direction. Otherwise, it will continue in courts as a matter of litigation. Or even if it continues in the court, it will go on a different trajectory, on a different logic. We'll be discussing that issue when any other news comes up in the aspect of freedom of religion or Article 25 in that context. I'll not digress from the issue. Let's stick to the issue here. Okay, just an example. So also we will see some other cases where this kind of conflict came up and how Supreme Court resolved that conflict. So the gray zones which are there, even when the legal provision is there, it is subject to interpretation. Only when situations come up, at that point of time, we will realize the importance of this jurisdiction. So it will resolve those gray zones and act as a bridge. Are these two different points? No. Explanation of the same point. Next up is separation of powers, which is the foundation of a functioning democracy. Clear? Okay. Now let's see. Do we have any international precedents? No. If you get a question in prelims, this is taken from Canadian Constitution. Is it true? True or false? I posted in the Telegram channel today. Did you open the channel? In the highlights itself, in the first paragraph, I have highlighted that point. It is taken from the Government of India Act 1935. But you also have in GS2 a topic, comparison of constitutions. So sometimes you need to know whether this kind of jurisdiction is available in any other constitution or not. It is in that context you are quoting Canadian model. Just like how we have Article 143, even there is this provision of asking their federal court or the Supreme Court for them for an advice on issues of importance. Clear? And it is not just specific for India's case, even internationally this is a good practice. So quoting this in your answers will give credence, some credibility. What do you mean by preemptive approach? Ensures constitutional interpretation happens before conflicts arise. This prevents political gridlock and complex legal disputes. Many times I've repeated this statement. It is always better to prevent and prepare than repent and repair. Institutions are like safety mechanisms. Let's say you take a chain which is having links. A chain, okay, which will have small links within that. The strength of this chain, we can say this chain is as strong as the weakest link. Is it correct? If the chain you see here is weak, what does it mean? It is weak because of the weakest link. And the strength of that chain will be determined by the weakness of this. So, similarly, any institution, if it has to function well, it depends on the strength of the weakest point in that entire system. To avoid such weaknesses, Article 143, as a matter of foreseeing the problems, we are using this Article 143. Clear? I'm going very slowly because you guys do not have polity basics. Is it done for everyone? Some batches are not done yet. Okay. Are you following? Everyone is following me then? So sometimes in prelims questions, when you get multi-statement questions, you need to know the clauses because this is there in use. Usually in prelims questions, it appears 1.5 year later, or let's say in 2025 prelims, sometimes current affairs of the last 3 years can be equally relevant. So this topic will be extremely important for you next year. Article 143, Clause 1, Clause 2. You need to know the difference. On any question of law or fact of public importance. So always use the Bare Act. Whenever you are reading news, use original constitution and look at the text. What is it saying? Each word can be important. In prelims, if you want to avoid confusion, reading this Bare Act is extremely important. Article 143, Clause 2 can refer pre-constitutional agreements such as treaties to the Supreme Court for legal interpretation. We have already discussed this. And not binding. Clear? Now, you can note these points down. See, writing these points in your answers will show that you are aware of what happened in the past. In today's article, you will see that there are as many as 15 times where this advisory jurisdiction was used by the president. Okay? You need not write all the 15 points. Nobody is expecting you to write all the 15 cases or the 15 scenarios where the government or the president on behalf of the government wanted to seek an advice. Okay? Some of the cases include Berubari Union. After the Keshavananda Bharati judgment in 1974, there was a lot of confusion. Even in such scenarios, the opinion was sought. Ram Janmabhoomi issue, Ayodhya, where the court denied on the grounds that this is not a legal matter. Okay. So you can note these cases down. Keshav Singh case. These cases can also be used while supporting your arguments in other topics. For example, this case, legislative privileges. So, what is Article 105? Homework. Parliamentary privileges, for example. What are the privileges of MP? Members of Parliament. MLAs, MPs. Okay. In those cases, what is the relevance of this Keshav Singh case? Know the facts of the case. Google and try to know about it. So, in one article you are revising, in one news article you are revising so many concepts. So, when you look at cases like this, you can also go back to Lakshmikant, read that parliamentary privileges topic, read this case, understand how that case is relevant in the Article 143 context. It will give you a sense of clarity. Clear? And finally, collegium reform, that is NJAC. Okay, it was stuck down. You must have known about this topic in your judiciary topic, appointment of judges, first judges, second judges, third judges case. Okay, why NJAC was stuck down. All that issue is a separate discussion altogether. But if that class is already taken, take this as an opportunity to revise that part also. Parliamentary privileges, judicial appointments. Okay, revise the basics. Clear? I'm going slow. If there is any confusion, please ask. Now, in the present context, what is the question that the president asked? First one. Can president or governor withhold assent indefinitely to bills? Why? Because refer to this judgment by okay. Second question. What is the context? SC verdict, that is Supreme Court. What is the purpose and the goal right now timeline was imposed, but what is the overall philosophy or methodology? What is the relevance of assent? What is the scope of assent? We need more legal clarity on the role of governor, and this is the reason why Supreme Court President asked Supreme Court. Similarly, there was also a question asked by the Vice President about about the grounds on which judiciary is involving. On an informal note, the Vice President had an opinion that this can be infringement of or the violation of Constitution because it is violating separation of powers. When the Constitution doesn't tell the timeline, how can judiciary tell the timeline? At max, maybe judiciary can tell that the legislature should come back and amend the Constitution to enforce a timeline. How are they dictating this is the timeline in which you should clear? Valid question. Because it is not the role of judiciary to make laws. It violates separation of powers, which is a part of the basic structure doctrine. You know what is basic structure doctrine? What is basic structure? Exactly. It is that element of Constitution which will keep the spirit of Constitution intact. Which case was it cemented? After which case this was cemented? Keshwananda Bharati case. So federalism and separation of powers, both of them are integral part of our constitutional philosophy. So according to the Vice President, there are on many occasions, if not on his official capacity, maybe on informal note, there was a question posed that this is a violation of separation of powers. Fair enough. So it is in this context the question was raised. Clear? Now, if you don't know what is the background of this whole issue, let's understand that original 8th April 2025 judgment by Supreme Court. But to understand that case, we need to know the provisions of the Constitution with respect to governor. What is governor's role? Why should we have a office of governor? Okay, another prelims question. From which source was the office of governor taken? You can go to Lakshmikant, refer by hearted. Sources of provisions of Constitution, in the making of Constitution, it's a area where you will get a lot of prelims questions. So by heart that. Tell me, what is governor's role? Why should we have governor's office? Purpose. Custodian of the Constitution. Then what is judiciary doing? Okay. What is the role of president at the center as the head of the state? In a republic, what is the role of the president? Why do we have a president? Or why do we have a governor? Permanent executive. See, constitutional machinery. You've heard this word, right? What do you mean by that? There is a specific design. That design has a purpose. What is that purpose? Peace in the society, ensuring peace in the society. When you have an elected government, you also need a, you know, sort of a manager between the center and the states. Governor plays that role. But what is the source of conflict? Who appoints this governor? President on the advice of? Invariably, Council of Ministers and center is from a single party or a coalition. There can be situations wherein the governor is appointed by the same Council of Ministers through the president, and at the state level the party in power may not be in favor of the center. So don't you think there will be a conflict? And it is in this context this question becomes all the more important. The purpose for which that office is existing can sometimes prove to be the anti thesis or roadblock for governance. Let's say a popular government, meaning an elected government through elections, people elected for that government, and in an indirect democracy, once you give power to the certain government, whatever law they make is considered to be legal. If the governor of that state does not give assent, it will not become a law. That is the problem here. As many as more than 10 or 20, somewhere around 20 bills were withheld by the governor. Now what will the state government do? Only when you have the power to do something as per the constitutional provisions, you are allowed to carry out the actions of welfare. When that is not happening, the very purpose for which they are elected is getting defeated. So this friction between the center and the states through the office of governor is what the Supreme Court wanted to adjudicate and resolve. Why? Because Supreme Court is the guardian of constitutional morality. The very purpose for which the constitution is designed is progress. When that progress is stalled, Supreme Court has a responsibility to see whether that roadblock is justified or not. If it is not justified, change it, fix it, keep the system running. It's like a mechanic servicing a bike to keep the engine running and prolong its longevity. As simple as that. When that is not happening, Supreme Court intervened and imposed a timeline. Now, the question asked by the Vice President is fair enough. So how do we resolve this deadlock? Through Article 143. So since these issues are given in our newspaper articles, etc., you are expected to know the basics from Constitution, Article 200, 201, 207, what are those provisions saying, etc. So that's why I'm just briefly bringing those topics up. You understood the whole issue? Clear? Now, once the concept is understood, memorizing is secondary. You may forget article numbers, but will you forget the logic behind this? That is what you should focus on. So originally, the 1935 Act created the Office of Governor to ensure that the states are under the control of the central government, British Empire. Now, what is the difference in that design and this design? Here we transform the office of governor as an agent of central control to that of a protector of the constitutional machinery at state level. Of course, there are checks and balances. How is the governor ensuring that constitutional framework is, withheld? Through his assent powers, pardoning powers. So you can go to the Lakshmikant chapter on governor and read about his powers. Each of those power and dimension of that power is a way of upholding constitutional framework in that state. But given the fact that he is appointed by the center, those duties can be biased, which will again tilt the balance into governor being an agent of the state center. I mean, this is not the original intent of our constitutional makers. So we don't want a reversal of the trend, because this is not healthy. It is not good for the whole concept of federalism. We need a situation where the center and states work together for the growth of this country. That concept is called cooperative federalism. This is what Niti Aayog discusses as a think tank. We have already spoken about this, right? So this tension is what we are discussing. Now what am I expecting from you? You should memorize the basic constitutional articles behind this. I am only explaining the concept so that you focus on memorizing later. First understand the concept. So what happened? 10 bills were withheld. This was referred to the president. Why is it referred to the president? What are the options available with governor when a bill is given to him? Withhold, give an assent, or return the bill, or send it to the president. Okay? You need to remember that. So when you withhold assent or just send it to the president, where president, does he have a time power, he or she? Time period is not there. Either you withhold it for some days, and then when the state government or the council of ministers are asking, when are you going to give me the test and we have to do some work, then refer it to the president. President will keep that for an indefinite period of time, because there is no constitutional limit on the time that you can take. It's a deadlock. You are not allowing progress, which defeats the very purpose of the existence of these offices. And obviously Supreme Court should intervene. After intervention, now vice presidents debate whether they can dictate timelines or not is a matter of procedure, but not as a matter of philosophy. Is there any question that Supreme Court should intervene or not? No. The secondary question, which is minute, which can be fixed, is that who should impose a timeline. So Supreme Court should ask the legislature to legislate and create a framework. Fair enough. Because procedural integrity, meaning following the procedures and everybody doing their own job, not snatching away their job from other wing of the government. What if the parliament takes the power of Supreme Court and says we want to give judgments? Obviously Supreme Court will not agree. So it is fair enough that this argument is also coming up. How can you create laws? Okay. So therefore, to resolve that, it's a very smart move by the Council of Ministers to seek a clarity and a framework on this whole issue. Okay, clear? Okay, what did the Supreme Court say? There is 1 month limit to act on first submission of bills, 3 months if you are rejecting, and 1 month deadline for reconsideration after the assembly pass. So, in short, timelines were imposed. Core ruling on governor's powers. So, what did the Supreme Court say? You don't have an absolute veto. It's not like you can indefinitely sit on it and not take an action. No absolute veto. Bound by advice. What do you mean by this? Governor essentially is just supposed to act on the advice of the Council of Ministers. Which article says this? Have a look. Okay. One. Have a look again. Homework. Because you have to quote this article in your answers. Clear? So this ruling will curb the misuse. Next up. What are the articles? 200, 201, 207, 163. Okay? 163. Note these articles down. You are supposed to memorize. Clear? Usually this would not have been important, but since it is appearing in news, now they become important. 200, 201, 207 and 163. Just note them down. So overall, this will maintain a federal balance in governance, this whole issue of Article 143 in the context of this governor issue. Clear? Issue is clear? So you get to know about President's power, governance power, advisory jurisdiction of Supreme Court, the important cases. When you are reading those important cases, you will also read the corresponding concepts. Let's, for example, you will read about parliamentary privileges. You will read about, when you are reading Berubari case, Berubari Union case of 1960, you will get to revise Article 1, 2, 3, 4, 5, not 5, Article 1, 2, 3, 4. So, this is how you are supposed to read current affairs. From one issue, you will revise multiple concepts. Okay? This one issue is enough for you today. Finish this issue. Don't leave it at that. Go back, complete it, give this a proper structure. You will do well. Okay? See you tomorrow.